Sit down, Grandfiller. All right, I'm going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives Begol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Pope. Here. Green. Scott. Madam Chair, you have 11 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Schutte moves to adopt the minutes from October 22nd. Hearing no objection, the minutes are adopted. Rep. Johnson moves to excuse absent members. There are none absent, so that's good. We don't need that, actually. Okay, next we are going to move on to House Bill 4843. This is a Rep. Mueller bill. As you know, we had a fun week last week on the different bills that he had. And first one up is 4843 in regards to the electromuscular disruption technology. There is a substitute, so Rep. Begol is going to move the H1 sub to House Bill 4843, and I'll just go ahead and explain that sub. The sub eliminates the reference to conducted electrical energy, CD3 technology, which apparently refers to one specific manufacturer's product. Instead, the substitute refers to an electronic control device that uses electromuscular disruption technology or conducted electrical energy technology. So the sub adds definitions to that. And with that, like I said, Rep. Begol moves that H1 substitute. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson. Yes. Schutte.
Yes.
Carter.
Yes.
Pope. Yes. Green. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
Okay. Next up, we are going to report the sub. So Rep. Harris moves to report the H1, sorry. Rep. Harris moves to report House Bill 4843 as substitute H1. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope. Green. Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 2 pass. House Bill 4843 is reported with recommendation as substitute H1.
Thank you, Madam Clerk. Next up, we are going to do House Bill 5079 by Rep. Mueller again. This is in regards to disarming law enforcement. There is a substitute, which I'll talk about right now. The sub adds 2 categories of persons to the definition of peace officer. Michigan State Police motor carrier officers and private security guards hired by the state to protect state-owned or leased property and facilities as provided under MCL 28.6C. And with that, we're going to have Rep. Wozniak move to adopt the H1 to House Bill 5079. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope.
Yes.
Green. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you, Madam Clerk. Next, we're going to have Rep. DeBoyer report House Bill 5079 as substitute H1. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope.
Yes.
Green.
Aye.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next, we're going to move on to House Bill 5080 by Rep. Mueller again. This is in regards to the sentencing guidelines for the previous bill. With that, we'll have Rep. Johnson move to report House Bill 5080 with recommendation. Madam Clerk, please call the roll.
Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Hope.
Yes.
Green. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next, we are going to move to testimony on a couple of different bills. In today's testimony, we'll be taken on numerous bills. So please note that oral testimony is limited to 3 minutes germane to the bills at hand. Testimony may be submitted to the clerk as well via email or written testimony. With that, I am going to call up, we're going to do testimony on Senate Bill 82, which is by Senator Chang in regards to the Judicial Protection Act. Go ahead. So we have Stephanie Chang's staff, Alan. Yeah, I know Alan. You have the floor. Thank you.
Okay. Thank you, Madam Chair and committee members. My name is Alan Heinitz. I'm the Chief of Staff for Senator Stephanie Chang. I'm grateful to have the opportunity to speak very briefly, so it's not Groundhog's Day, about the Judicial Protection Act. This is a reintroduction of what was Senate Bill 871 and House Bill 5724 from last term, and it's identical to the original version of Rep. Lightner's bill that you're going to hear today. That's also on your agenda and that you heard testimony on earlier this year from Chair Lightner, so again, brevity. I do want to note Senator Chang's appreciation for Rep. Lightner and her work on this issue and the productive partnership between our offices. She also wants to thank Rep. Kelly Breen for her partnership and hard work on the Judicial Protection Act too. So this legislation was developed in collaboration with the work group of state and federal judges as well as the State Bar of Michigan to address the deeply concerning uptick in threats against judges by protecting their personal identifying information from disclosure. I think most of you understand what the bill would do. I did want to note that along the way, this language was sharpened and made more functional by incorporating feedback from several groups like the County Registers of Deeds, some internet data groups, and real estate websites like Zillow. At some point, I think most of you have heard testimony from U.S. District Judge Esther Salas and also from Michigan Court of Appeals Judge Brock Swartzel on this bill. The only change to Senate Bill 82 since last term and since it came over here is that it is now going to be tie-barred to Rep. Lightner's Elected Official Protection Act. So we think passing the JPA and Rep. Lightner's bill are going to be critical during this challenging time. And if anybody has any questions, I'm happy to answer them. See, this is why y'all are my favorite House members.
Thank you, Ellen. I'm going to go ahead and read in some cards in regards to Senate Bill 82, and then I'm going to speak to 4397 in just a moment as well, since the two go hand in hand, and there's a substitute for 4397. In regards to Senate Bill 82, does not wish to speak, supports the bill. Monica Martinez of the Michigan Judges Association does not wish to speak, and is neutral on the bill. Nate Love from Consumer Data Industry Association does not wish to speak and supports the bill. Trevor Van Dyke of the State Court Administrative Offices does not wish to speak and supports the bill. Nathan Triplett of the State Bar of Michigan. And then I'll go ahead and move into the one. I have a card. Jody White wishes to speak, is opposed to the bill, and is from VIP's Victim in Probate. Jody, would you please come to the table?
Try to read fast.
Talk fast.
Jody White, Livonia. Why shield judges while probate courts destroy families? Why is Michigan rushing House Bill 4397, the so-called
Madam,
Judicial
we are
Protection
talking
Act
about Senate Bill
modeled-
82.
Oh, mine said I wrote 43. Oh, my apologies. I know what I wrote.
If you want to wait, what we
I
could
can
do
wait.
is we'll have all of you come up
That's what I
and you after the 4397.
I was going to do 6 minutes. No, just kidding. That was kind of fun. Sorry about that. I did write that. Yeah, but I wrote both down.
I didn't, what is that bill?
It's the same thing.
Well, we don't know. She's saying there's something called,
This is the replacement for this. Senate Bill 82.
she just said there's two bills, right?
Yeah, this is the replacement, 4397.
So they're gonna talk about this first and then talk about this and
I
then
don't
say
know,
that.
maybe. I don't know what they're doing.
We're gonna go at ease for a moment.
I'm fairly confident that substitute for Lightner's bill is a completely different bill. And it's more about the description. Senate Bill 82 is still in the Protection Act.
So we do want to speak for 82 then. So we need to change. So we want to get back up there. We're changing. Thank you, Ms. Breen. So we do want to be on 82. Yes, ma'am, sir.
Bill 4397, was that incorrect?
Yeah, we want to be on Senate Bill 82 because she just said that they're different. No, here, hand them all back because I changed them all. So we want to all speak. Yeah. Thank you, whoever did that. Okay, so. And we're all going to go.
Is there, are these, can they explain what these bills are?
Well, she just said, she says that one is for the legislators and one is for the judges. We want the legislators, and we want the judiciary, we want the judiciary.
Oh, okay.
We'll call this meeting back to order. Okay, so we had obviously some confusion there with the bills. So we will go back to testimony on the bills. Jody, if you would like to come back up, you know, you're going to reference Senate Bill 82 in regards to JPA. And again, I ask that you keep your comments to 3 minutes, please. Thank you.
Why should judges, why shield judges while probate courts destroy families? Why is Michigan rushing to Senate Bill 82, the so-called Judiciary Protection Act, modeled after a federal act sparked by one of a 2020 attack on a judge's family by a disgruntled attorney? Meanwhile, our probate families and their attorney allies are ravaging dozens of Michigan families. No federal tragedy required. No laws shield our loved ones from elder abuse, stolen legacies, or shattered lives. Equal protection under the law is the bedrock of our civil society, enshrined in the 14th Amendment. It demands that no one, not judges, not the powerful, stand above accountability. Yet here we are debating Senate Bill 82, which lets any judge, state, federal, tribunal, demand public bodies and private citizens remove their home addresses, phone numbers, license plates, even children's school routes within 5 business days or face lawsuits. This isn't safety, it's secrecy. It's a shield for judges' privacy, including hiding assets and addresses, risking cover-up of conflicts like hidden trust wealth, while victims beg for transparency. Judges already have security. We need accountability. Legislators, please serve the people. Mandate timely jury trials, expose elder abuse and probate, uphold equal protection, not this elite exemptions. Quickly, because Jeff White's my husband, his ordeal in probate court where he was not protected by a judge, because in 2014, him and his brother fought for a jury trial to challenge an amended will and trust, undermined by undue influence and embezzlement. The probate judge erred in 17, granting summary disposition, and then 18 months later, the Court of Appeals overturned the error, by the way, by Brock Swartz, who came here and likes this bill. But he did the right thing. He did send it back to trial for a jury trial, but it was denied a second time because Jeff lacks standing now. Decades of agony. We want some changes. Finally, a conviction. Hallelujah. By the way, we have a conviction.
Jody,
November
can you speak to the bill, please?
of 24, which I one more sentence. The one co-trustee's conviction on the criminal enterprise and embezzlement, while the other family, the other co-trustee, an attorney, he gets left off. Thomas Brennan Fraser and the probate judge were left untouched and protected. Over a decade of pain, victims are increasing in probate because of the judges and the attorneys. They twist guardianships, enable corruption, and jail family members. Dozens of families are gutted in the last decade. Their homes are seized, savings vanished, rights are crushed, loved ones are isolated. Every
Jody,
day.
I asked you to speak to the bill. This is not to the bill. We are not talking guardianship right now. We are
is
talking
the
protection
bill
of
because we're
judges.
protecting the judges and not the people. So, okay, then how about it? Legislators reject it. Instead of crafting laws to protect the judiciary, state actors work for the people in 2025. Demand transparency, deliver justice, and restore trust. The Michigan families deserve better. Thank you.
Next, we'll call up Javante Tubbs, representing Bobby Moore Biles, opposing the bill and wishes to speak. You have 3 minutes. Thank you.
Thank you. Everything Jody just said on top of, you guys are grandparents, parents, you know when people intentionally are not being transparent that they're hiding something. The dynamic of judges being possibly targeted, but that's been a dynamic since the inception of courts. We're not gonna buy that right now. We can't allow them to play in y'all face, and that's basically what they're doing. The judges are basically stealing people's estate. They stole my aunt's estate, and my Aunt Bobby Moore. She was a court. She worked for the courts. Murkowski looked her right in the eye, called her a friend, called her a colleague, while stealing her house. Her house is right now for sale, private sale.
Sir, can you speak to the actual bill itself, please?
Well, this is the bill. The bill is privatizing for judges. My aunt's house is being privately sold right now by the probate court in Kent County. So this is exactly what that bill is doing. And if
This bill just protects their addresses, so people can't find them as easily. That is what this bill basically does.
okay, so why? So then why the private?
So the guardianship
Why
stuff.
the privatization then? Why the secrecy? I mean, this is all. It all is correlation. It's just like Jody was saying. It all correlates. If they're trying to hide behind something, they're going to hide more than just their addresses. They're going to hide more than just their numbers. They're going to start hiding other things, and it started
Okay, well,
already.
you
So,
know, sir, I
our 3
warned you
minutes
about
is
what
not
this
up
is.
either.
This is about addresses, Judicial Protection Act.
Mm-hmm.
This is to make it so it's not as easy to track down judges and/or, well, as you'll hear in the next bill, other elected officials. We do still have mechanisms for financial disclosure that we have to provide. And so do
But there's
judges, all elected
absolutely no
officials. So, sir, I'm
accountability.
going to ask you to go ahead and take your seat, and we're going to move on to the next person. Thank you.
I can't finish?
You can submit testimony.
You let Jody
written.
finish. Can I finish?
You have 55 seconds.
Okay, to the rest of the legislators, could you guys please stop allowing these judges to play in your face? Could you please stop allowing them this privacy, this secrecy, this kind of elite type of a position that allows them not to fall under the regular jurisdiction of normal laws for normal people, and stop allowing them to steal our state. They've been doing it since the beginning of America.
Okay, next we have Tom Howe, the citizens of Michigan, wishing to speak and opposes the bill. And Tom, please limit your comments to 3 minutes. Thank you.
Thank you for having me today. This bill, Senate Bill 82 here, has been, you can go through this and analyze this. And American Civil Liberties Union of Michigan, the Reporters Committee of Freedom of the Press, and the Mackinac Center for Public Policy argue it convenes the Michigan Constitution. As you know, as public functionaries, you all swore an oath to the United States Constitution and to the state of Michigan Constitution. Yet here we are today trying to pass a bill that's unconstitutional. It's very easy today to take and analyze these bills and go through these things, and all of you should learn how to do this if you haven't so far. Under Michigan Constitution, Article 6, Section 9 requires circuit court records to be open to the public inspection, and Section 10 applies this to district courts, mandating transparency to foster public trust in judiciary. Senate Bill 82's compelling redactions of judges' personal details in the court documents could obscure critical context in cases involving judicial ethics, conflicts, or misconduct. And we all know our court systems now are ripe with misconduct. And here today, what we need to be focusing on is the impeachment of these judges across the state of Michigan. This is a waste of your time to be operating on this bill here by the Michigan Bar Association, trying to protect their membership and the Judges Association. So these people have all banded together to defraud you and the public. And this is my opinion, but I think the state of Michigan and all the residents of the state of Michigan will agree. We're taking our state back, okay? So here today, we need to have this state turn into, we're gonna make Michigan great again. And by getting rid of this bill and making these judges who are earning $187,000 and up a year do their job legally, okay? And what they're doing here, because the Michigan Constitution said they had to be licensed, and yet the Supreme Court has said a bar card is a license, which it's not. And these sit on the bench as 3 bar card members against the public, defrauding the people across the state of Michigan. And we're tired of it. We're sick of this, and you guys should be sick of this too. And you should shut this bill down immediately, and it shouldn't go any farther. And we can go on and on and on here with this nonsense that the Michigan Bar Association brought in front of you. So we can go on and say here, the court records, redaction requirements, court records, public documents, databases must redact such information to prevent public access. And let's see, we go down here. 80 is considered unconstitutional. Let's see, let's go down here where I left off here. Article 1, Section 5 of the United States Constitution guarantees every person the right to freely communicate thoughts and opinions with explicit protections for truthful speech about public officials, including judges. Criminalizing the transfer of public information.
Tom, you are out of time. If you would like to submit your testimony, you can email it to the clerk, or you can write it as well. And we're going to move on to the next person because we have some judges on Zoom as well.
All of you need to learn how to know what's constitutional and what's unconstitutional.
Thank you, sir.
So
all right.
Please vote no on this.
Next, we are going to, Next, we're going to go to Peter DePhillips. I'm sorry, I might have.
Yes, good morning. My name is
Peter
Phillips. And
wishing to speak in supports the bill with restrictions. Thank you, sir. Go ahead. You have the line.
Yes, my name is Peter Phillips, and I'm proud to be a nearly 65-year-old man with no criminal history and a track record of over 30 years of volunteerism in my community. I ask you in advance to please treat me with the proper courtesy and respect and refrain from continually interrupting me while I attempt to enter my comments on record. If that happens, I will reclaim my time. These 2 Senate bills, 52 and 4397 was prompted by the Daniel Andral Judicial Security Act, and I offer my condolences to his family. In the event those who are not familiar with what happened, 48 Hours did a segment entitled The Delivery Man Murders. And in a nutshell, a disgruntled lawyer, a lawyer, drove across country to California, disguised himself as a delivery man, and murdered a fellow attorney, and then drove to New Jersey, where this time the same disgruntled attorney attempted to kill another fellow bar member who happened to be a judge, but ended up killing her son and shot her husband. However, please note that critics of this bill have accurately stated that Congress can protect the safety of judges without censoring and banning truthful speech. Securing the safety of the judiciary is a worthy goal, but it's one that can and should be achieved without infringing on First Amendment, constitutional, civil, and human basic rights. The reason I am here today is because my First Amendment rights have consistently and egregiously been violated in many Michigan courtrooms by the antics of these black robe diseased judges who sit on the benches, and they were also violated by the very chair of this committee, and that would be you, Kelly Breen. What happened specifically is when this bill was 5724 in June of 2024, and Kelly Breen was the chair, she adamantly refused to allow me and the majority of the members.
Sir, I'm going to ask that you stick to the merits of the bill. We are under a new bill right now, and you have about a minute and 10 seconds. Thank you.
Been observed that using power to not allow free speech and stymie all opposing voices is a hallmark of fascism. Apparently, Kelly Breen does not agree with that.
Sir, can you please stick to the merits of the bill?
I'm claiming my time. My endeavor and desire are to see much needed reforms made to the courts in Michigan through legislation, because the Michigan judiciary, as has been consistently pointed out by everyone who spoke before me, they're currently allowed to operate with no checks and balances in place. The Judicial Tenure Commission is well known to be a useless sham of an organization and even appears to operate with a racist bent, that they were forced by the Michigan Supreme Court to be audited for this reason. This committee seems beyond obsessed with this bill, and as it's been on the floor for well over a year. But why isn't there any legislation being introduced to protect innocent civilians from the documented and widespread systemic cases regarding the antics of these black robe disease judges that sit on Michigan's benches? And two of those judges happen to be in that meeting room on June 2024.
Sir, thank you for your testimony. If you have further testimony, you can submit it written, email it, or email it to the clerk, or submit it written. But I asked you to speak to the merits of the bill, and you failed to do that. So we are going to move on. The next person we have is Cynthia Mufsud. Mufsud. I'm sorry. Wishing to speak, opposes the bill. And Cynthia, if you could keep your comments to 3 minutes, I would appreciate that. Thank you.
Is this on? No?
Yeah.
Chair Lightner and honorable members of the Judiciary Committee, thank you for giving me the opportunity to speak. My name is Cynthia Mifsud, and I'm here as the daughter of an elderly mother whose estate was drawn into years of abuse and exploitation through the probate system. I fully support the intention of SB 82 to protect the safety of Michigan judges and their families. Judges have a right to be safe in their homes and to shield their primary residence from public posting. However, this bill as written goes far beyond protecting a family. It allows judges to hide all property addresses, including investment or commercial holdings, that creates a dangerous loophole. Over the last 4 years, I've witnessed firsthand how real estate belonging to elderly and vulnerable people is sold undervalued to attorneys, realtors, and sometimes those with judicial ties. These transactions often happen quietly, without scrutiny, and without the heir's knowledge. When judicial officers can also hide their investment properties from public view, the public loses any ability to detect conflicts of interest or patterns of profiteering tied to vulnerable persons' estate. It is perfectly reasonable for a judge's primary residence to be protected from disclosure. But when it comes to investment properties, rental homes, or any real estate held through LLCs or trust, privacy becomes secrecy, and secrecy erodes trust. Judges hold extraordinary power over family property and liberty. With that power comes a heightened duty of transparency, especially in probate and guardianship matters where the elderly or disabled have no voice. SB 82 seeks to protect judges and their families by restricting access to personal identifying information. While personal safety protections are appropriate, the bill as written could unintentionally conceal judicial misconduct and further victimize families who are already struggling to obtain accountability in Michigan's probate courts. In my mother's case, the judge ordered an independent medical exam under the wrong statute. He backdated letters of authority. There was a new judge assigned, and he continued to hear the case and put orders in. I mean, there's no accountability at all for these judges, and now they're going to be given further carte blanche to do whatever they want to do, and they're able to hide everything. Each of these actions that I just spoke about occurred within the existency of secrecy. Unrecorded hearings. The judge even ordered my hearing not to be recorded. I wasn't allowed to be present.
Ma'am, please speak to the bill.
I'm speaking to the bill.
10 seconds.
That's fine. The privacy, the secrecy is where there's problems, and we want transparency. We deserve transparency. Thank you.
Thank you, ma'am. Next, we have
Great job. Spoke on the same thing I did. She cut me off, though.
It's the same story.
next on Zoom, we have Judge.
They won't cut him off, watch.
We'll see how long he gets to speak.
Oh, never mind. We're okay. We're going to move on to vote on Senate Bill 82. I will move to adopt the H3 sub to Senate Bill 82. Will the clerk please call the roll?
Chair Lightner,
Yes.
Representatives Begol,
Yes.
Wozniak,
Yes.
Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Schutte,
Yes.
Carter,
Yes.
Hope,
Yes.
Green, Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
All right, thank you, Madam Clerk. Rep. Begol moves to report Senate Bill 82 as substitute H3. Will the clerk please call the roll?
Chair Lightner,
Yes.
Representatives Begol,
Yes.
Wozniak,
Yes.
Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Schutte,
Yes.
Carter,
Yes.
Hope,
Yes.
Green, Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. Senate Bill 82 is reported with recommendation as substitute H3.
Thank you, Madam Clerk. Next, we're going to move on to House Bill 4397. As you know, this was originally the JPA, as we just similar to what we just passed. However, it has been substituted out, and I want to talk to the substitute. The substitute basically creates the Elected Officials Protection Act, designed to protect the personal information and physical custody of public officials, their families, and household members. This sub will cover elected members of the Michigan House and Michigan Senate, the governor, lieutenant governor, attorney general, secretary of state, and persons elected in Michigan to serve in the United States House and Senate in addition to former governors. With that, I will move to adopt the H6 to House Bill 4397. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol,
Yes.
Wozniak.
Yes.
Harris,
Yes.
DeBoyer,
Yes.
Johnson,
Yes.
Schutte,
Yes.
Carter,
Yes.
Hope,
I actually have a question.
okay.
Go ahead, I'll just grant you leeway.
How is, Madam Chair, thank you. I'm wondering how this will work when we have some election laws that might be conflicting as far as disclosure of addresses and campaign finance laws, and where judges are, well, not, this won't apply to the judges, but for elected officials. A lot of that information's out there. I'm wondering how this will work in congruence with that.
Sure, and actually it is out there for judges as well. It's going to follow the same process. This one will fall under DTMB. There's going to end up having to be trailer bills. I have spoken with some members of your caucus already who are looking at the disclosure part to do the trailer bills for the particulars for the disclosure itself, because this will follow the same guidelines like with the county clerks as judges. It's the same type of request form, only ours falls under DTMB instead of state court administrative offices.
Okay.
Thank you. Please continue. Returning to the vote.
Adopt the H6 substitute to House Bill 4397. Representative Carter gave the last vote. Representatives Hope.
Yes.
Breen.
Aye.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
All right, thank you, Madam Clerk. Now that that sub is adopted, we can actually talk about the bill before we report it out of committee. So, Rep. Johnson.
Thank you, Madam Chair. I just wanted to make the comment to those who have spoken up. This bill in no way invalidates your concerns for injustice done to you and your families in all sorts of measures. It does not invalidate the fact that we need to look at many other areas of the law and deal with the injustices, and we hear you. It's not exactly what this bill is about, so that's why there's a separation there, but we hear you. And we will work on these things.
You violated your oath of office by passing.
We're not going to
Yeah.
communicate right
I'm-
now. I'm
we're
going to
just-
move on to the next
thank you.
question. Rep. Breen.
Thank you, Madam Chair. And I need to make a clarification, so this is on the record. And to the folks that testified, we've been through the ringer on on a lot of these issues. And we do have guardianship reform bills that have been dropped. But regarding your complaints, and I do feel for you, and I know what has happened to your families and your parents has been horrific. There are requirements that judges are supposed to file, and they have to abide by, particularly the judicial canons and the codes of judicial misconduct. But I remember asking this question last year. If you want to hold judges accountable, you can do it at the ballot box. You can do it in many other ways, but you don't need to know where their spouse works or where their children go to school in order to hold them accountable. These threats are real, and not just against judges, but against elected officials. My life's been threatened. My daughter's life has been threatened. Judges' lives have been threatened. This isn't about hiding them from their actions, but this has to do with protecting their families as well. That is, so,
The
that's
committee will
what I
come to
needed to
order.
make that
Audience,
clarification
please,
for.
Please, just a moment. Go ahead,
Thank you,
Kelly.
Madam. Yes, again, I would encourage you, if you have problems with disclosure and holding judges accountable, to look at those pieces of legislation and laws that we have out there. Right now, the threats are real, and there are ways, I believe, to address the problems that you've been facing that don't have anything to do with this bill, which is designed to keep people from being harmed and assaulted and killed. Thank you.
Thank you. We are going to move on to report. This will come to order. Members, please. We are trying to conduct this meeting. You can talk with her offline. Thank you.
Thank you, we'll talk to you offline, thank you. But we want them impeached, and you guys can do that. But thank you, Ms. Breen.
Okay. I will move to report House Bill 4397 as substitute H6. Will the clerk please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Hope. Yes. Breen. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, 0 pass. The motion prevails.
Thank you, Madam Clerk. I need to read in the card for House Bill 4397. Does not wish to speak, is neutral on the bill. Nathan Triplett of the State Bar of Michigan. Okay, next we are going to move on to House Bill 4749, Rep. Roth, in regards to the Antrim County Trial Court System and a judgeship there. Oh, yes, and we do have your judge on Zoom right now.
Yep.
And they can testify as soon as you're done.
Yep, just give a quick start to it. So we've run into some real issues of getting folks to court because of the distance that is involved. So I want to talk about geography. Just to give you an idea, Leelanau, Grand Traverse, and Antrim are in a court system today. The highest point on the Leelanau Peninsula to this downtown Traverse City is 45 minutes. From Bel Air, it's an hour and 5 with good traffic. This has become a real issue, especially with a lot of the different cases, including drunk driving, getting folks to Traverse City to get a court, and then one of the judges, they share 3 judges. One judge makes an appearance about every 2 weeks up in Antrim County. This is not service. This is not the right way to do it. The geography of Torch Lake, if anybody's been up in the Antrim County area, you can't get from Elk Rapids to Bel Air, which should be about a 10 to 15 minute drive, without a 45-minute drive. So you're trying to get through the county. It just doesn't work very well. So, and I don't want to just put it all on Antrim County. Grand Traverse County is 100,000 people today. Their court system is overworked themselves. By separating a judge out to Antrim County gives a lot more service for both, and it alleviates the issues from Antrim in Grand Traverse. So it's a thing that worked out very well. Grand Traverse County and Leelanau are supportive of this change. Antrim understands it may cost them a few extra dollars, but they're going to get a lot better service and better efficiency because the judge is going to. SCAO said that the judgeship there in Antrim by itself would be 1.5 judges. We're going to have 1 judge, and they are going to do district and probate. So I think overall, its efficiency of this works a great way. And I'm not going to talk much. I want to let Judge Stacy Truesdale talk about the situation up there herself, right from the horse's mouth. Oh, that's not a good word. She's a lovely lady. Stacy, if you're on board.
Judge, are you on Zoom? There you go.
Thank you.
Sorry for Rep Roth's reference, to the horse. So
That's all right.
Don't
We
mind
see
him.
each other. That's fine. Madam Chair and honored representatives, thank you for allowing me to speak today. Thank you especially to Representative Roth, who summed up the situation, but also to Representatives Borton, Kafia, and Long John for supporting this bill. HB 4749 has been, I should say, in the works for a number of years. The bill that is in front of you has been thoughtfully considered over a period of years, and there's been consultations with court administrators for all three counties, district court judges, Judge Stepka and Judge Cooney, who serve all three counties, our county court administrator, our county commissioners. I believe that Jeremy Scott, who is our county commissioner, is also present. State representatives and SCAO as well. In other words, this has not been taken lightly. I was elected in November of this year or last year. And while I was out campaigning, I had the opportunity to speak to a lot of people in Antrim County. Antrim County is vast. I'm sure a lot of you know that. And instead of having one major urban area, we have many small satellite areas. For example, people who are in the northern part of the county, they tend to go to Gaylord, which is in another county, to do their shopping and for their daily necessities. People in Elk Rapids, which is diagonal from the northeastern part of the county, they go to Traverse City for these things. I believe Grand Traverse is central and has done a great job in sort of being the hub of the three county district court. And I also believe it's possible to move on to a different state without casting blame or being unhappy. I think the whole bill is going to be very efficient. I think most importantly, members of the committee and Madam Chair, it is efficient, and this bill would allow Antrim County citizens to receive services within their county without the need to travel so far. For example, there is a sobriety court in Grand Traverse County, and Antrim County cases may attend that, but it as Representative Ross said, it takes an hour to get there. And we don't have public transportation that goes all the way to that sobriety court. So our citizens are very much hampered by being able to get access to services they need. We are able to provide that here in Antrim County. Additionally, for our citizens, having local court staff and administrators here rather than Traverse City, I think will expedite filings and will have quicker turnarounds on not only court filings, but also communications. I will be, luckily, the judge. I'm the probate court judge. I will be the judge who will preside over the district court. Now, that is going to double my docket. And I'm all in favor of this. I think it's really necessary. As you all are well aware, one of the reasons why family court was founded was because we felt, or the legislature at that time felt, that one family, one judge was a really good way to do things. And I can tell you, having been a prosecutor, I was the chief assistant prosecutor prior to becoming judge. The families we see and we serve here in Antrim County, there is a crossover between criminal courts and family courts. And I think sometimes not having the same judge handling those cases doesn't give the families a full picture of services available, doesn't give as many opportunities. For example, if I were to oversee a case in criminal court, I would know what would be going on with the parents or the adults. A lot of times that behavior trickles down through the family into the minor aspect, and those are the folks and the kids that I do see now. So I think I just want you all to know this has been very carefully considered by all aspects. We've involved DHS, we've involved counselors, we've involved our local community mental health. I think that this bill will provide efficiency and tailor-made services for citizens of Antrim County. And I thank you. I apologize, I've gone over my 3 minutes, but I am available for any questions, should anyone have any.
Thank you, Judge. I do have one quick question. It's my understanding you guys were asking for a year after the bill is effective to implement this and get it worked in the budget. And is that accurate?
That's accurate. SCAO asked for that the date of the signing by the governor, if this bill does go through, would then enact the new court. So that is something they asked for, and would we like it earlier? Sure, but we're willing to abide by what SCAO would ask for and get it done. It'll be a year from the date of signing.
Thank you. Rep. Wozniak.
Thank you, Madam Chair. With the appointment being postponed for 12 months, how long would that appointment continue, and if you know what election cycle?
You got elected in 24, Judge, and
Yes.
6-year term, so
Yes.
it would
Yes.
be through 30 at least, yeah. Is that, maybe I'm not answering that correct
You're
way.
correct.
Good try.
You're correct,
Good
Rep.
try.
Thank you.
Okay.
I would like to add, if I may, and not to contradict Representative Roth, who has been ever so helpful in this, we are willing to take on whatever is necessary in order to move this along. I think a year gives everybody plenty of altitude, but we would do what we feel is necessary in order to serve the citizens best. My court staff is very much in favor of working with the crossover, and we understand that there's going to be a transition period. We're happy to take whatever assistance from SCAO and Grand Traverse County we can get, and we're standing by to get started.
Thank you. Rep. DeBoyer.
Thank you, Madam Chair. I'm familiar with what you're trying to accomplish. St. Clair County has a single circuit court, single district court, but they do have a district court that is separated also. So we have it in 2 locations because of the length. It is at about an hour and 15 minutes from the south end of the county to the county seat. So similar circumstance. My question is, I do see that there's a fiscal analysis that hasn't come out yet. Is there going to be an additional state cost to this, or is it really going to be more the
I believe
district?
it's local in the county, Jim.
Right, for the staffing and those kinds of
Yeah.
things. No additional state expense. No additional judge, obviously, right? A judge
Maybe.
is moving.
We can get that for you.
Yeah, okay. Thank you.
I do know that county is going to take on some more cost also, yeah. But they are willing, the Court of County Commissioners is willing to do that.
Thank you.
Thank you. Okay, with that, we're going to move on to cards in regards to House Bill 4749. Does not wish to speak, supports the bill, Samantha Gibson of Michigan Association of Counties. I'm guessing, Trevor, you don't wish to speak on the bill? Okay. Does not wish to speak and supports the bill with some changes, Trevor Van Dyke from Scale. And that's it for that bill. Next, thank you. Next up, we're going to take up House Bill 4833, Representative Steele for a district court judge in Oakland County.
Thank you very much, Madam Chair and committee. And I have with me today Honorable Diane DiAugustino from the 48th District Court. And I'm going to speak first, but if I can make sure that she's there, so I'm not sure how to pull her up. Diane, yeah.
Judge Diane, are you on Zoom?
Pull her up.
Yes, I am here.
Okay. We're going to have Rep. Steele speak
I'm
real
trying
quick.
to turn on my camera too. I am sorry.
It's fine. You have a few minutes. We're going to have Rep. Steele introduce the bill real quick, and then we'll have you speak immediately following. Thank you.
Thank you.
Thank you. So I'm speaking on House Bill 4833, and it preserves the third judgeship in the 48th District Court. So in the 2011 legislation, bills were passed regarding the reduction of the judiciary. So the analysis at that time concluded that the 48th District Court had a judicial excess of 0.7 district judge. So as a result, the legislation decided that they would reduce one judge through attrition. So either they would age out, or if they retired. So then they would be down to 2 judges. So while I am a limited government legislator and generally support efforts to reduce the size of government, I am also a Milton Friedman fanatic. So one of the 3 things of government should be that we provide military support, enforce our internal contracts, and protect the citizens from crime. And having a strong judicial functioning service within our communities will provide civil society and make sure our communities are safe. The basic levels of what government is intended to do. We need our judicial liaison to be able to protect our personal freedoms. So since 2011, there were sweeping reforms that have been enacted, including criminal justice reform, landlord-tenant law changes, clean slate legislation, auto insurance reforms, and more. And each of these have significantly expanded the responsibility and the caseload of our district courts, requiring additional judicial time and resources. So the 48th District Court serves 7 municipalities, Bloomfield Township, West Bloomfield, Birmingham, Bloomfield Hills, Kego Harbor, Orchard Lake, Sylvan Lake, and reducing the court would jeopardize the court's ability to keep pace with the caseload. And so by saying yes on House Bill 4833 would preserve the 3-judge bench system that is currently prevailing right now. So with that, I would like to pass it over to Judge DiAugustino, and hopefully we can see her face as well. Oh, lovely. Thank you. Now we can't hear you.
You're on mute. There you go.
Can you hear me now?
Oh, yes. Thank you.
Hey, thank you all very much. Good morning. Thank you, Representative Steele and Chairperson Lightner and distinguished members of the Judiciary Committee. My name is Diane D'Agostini, and I am the Chief Judge of the 48th District Court. To tell you a little bit about myself, I've been a judge for 25 years and was elected to the 48th District Court in 2000. Prior to that, I was an assistant prosecutor in Oakland County for 9 years. My election in 2000 was profound for my Chaldean community, as I am the first judge of Chaldean descent in Michigan. Like many, my parents came to Michigan from Iraq to seek the American dream in the late 50s. And I can say without hesitation to all of you that my election as a judge was reaching the American dream. I have been reelected 4 times since my initial election. In each of my 3 contested elections, I have won every precinct in my 7 communities. I tell you this so that you hopefully conclude that I come here credible in the understanding of my community and the dedication that I have in serving them. Representative Steele went through the jurisdiction of the court, so I will not do that. But while the 7 communities are the voting communities, anyone may have a case in the 48th District Court facing either a misdemeanor, felony, civil case, landlord-tenant, small claims, or traffic case. As you probably know, the District Court is the most widely used court by the public. Again, Representative talked about the 2011 legislation. I'd like to just state that due to the significant legislative changes over the past 14 years, many stakeholders are concerned with the consequences should the reduction become effective. Stakeholders include my colleagues, Judge Small, Judge Barron, court staff, police agencies, attorneys, and local municipalities. Since 2011, the legislature has implemented a myriad of changes, from criminal justice reform, landlord-tenant modifications, clean slate legislation, auto insurance reform, and more, all of which have significantly increased the court's caseload and the complexity of case adjudication. Additionally, please take note, the court's civil docket has burgeoned with an increase of 84% since 2021, and it continues to rise. If the reduction occurs, the plan would then require additional staffing at the court and would shift more costs to the court's local funding units of Bloomfield Township, West Bloomfield Township, and Birmingham. Thus, I implore your committee to evaluate the serious ramifications that will occur into the future if the court eliminates the judgeship. I have also made contact with most of the legislators in the courts district on this issue, and I have received enthusiastic bipartisan support from both your colleagues and the senators. I would like to now testify on HB 4833, and I hope my remarks will be useful to this committee. Please stop me. I know that you have had a long morning. I just want to go through some of the numbers to help you understand how our caseload has increased on the relevant cases, not civil infractions, but relevant cases. I'll start off with auto insurance reform, civil cases. In 2019, no-fault insurance amendments caused our caseload to significantly increase. These cases involve parties filing increased summary disposition motions, which require laborious hours of research, analysis, and oral argument. In 2024 alone, the civil docket had a 58% increase compared to 2023. These reforms did not exist in 2011 when the judicial reduction plan was enacted. Clean slate legislation, as you know, in 2021, legislation went into effect which automatically set aside convictions and also greatly expanded the type of convictions that were eligible to be set aside. Under the new legislation, the number of hearings has increased mostly because operating while intoxicated, known as drunk driving, is now eligible for a set-aside. So in 2019, 38 set-aside hearings were filed. In 2024, the court surpassed 150 set-aside hearings, which require the judge to now review all of the closed files, hold a hearing with the defendant, and make specific findings on whether that conviction should be set aside. In 2011, these mandates did not exist. Criminal justice reform, effective in 2021, this legislature enacted new sentencing guidelines in violation of probation mandates. These changes require more time at violation of probation hearings and at sentencings. Defendants also are now allowed to ask to terminate probation after completing half of their probation. This requires, again, many additional hearings for each judge. These mandates, again, did not exist in 2011 when the reduction plan was enacted. Landlord-tenant changes. In 2023, the Supreme Court issued an order that continued and expanded provisions of the Landlord-Tenant Act that were used during COVID. This order currently mandates an additional day of landlord-tenant hearings for each judge, which is often over 60 cases. Again, this second hearing mandate did not exist in 2011 when the reduction plan was enacted. Police agencies. Unlike most courts, our court provides service to 8 different police agencies. The reduction plan would impact the police agencies and would cause delays for their needs. Police regularly seek a judge or a magistrate for many matters, including search warrants, swear-to complaints, or arraignments. The court must be available 24 hours a day for search warrants. There has been a major increase in search warrants, and I believe it's correlated to the rise in digital crimes and evidence. At present, search warrants are handled by the judges and magistrates both during the day and after hours. In 2011, the police sought out 241 search warrants. In 2017, 394 search warrants, and last year, 725 search warrants. Our DWI drug treatment court. In 2021, the court's new hybrid treatment court was instituted for the treatment of substance-using offenders and to protect the community. It did become certified by SCAO in 2023. This specialty treatment court requires additional hearings with defendants, evaluations, probation meetings, graduations, and SCAO mandates. The treatment court did not exist in 2011 when the reduction plan was enacted. Michigan Indigent Defense Commission, created in 2013 to foster improvements to the legal system, the MIDC works to ensure the state's public defense system is fair, cost-effective, and constitutional. The commission changed the fee structure for appointed attorneys, reflecting the time and effort expended on each case. Attorneys are now holding more preliminary exams, motions to dismiss, and jury trials than ever before. Again, these modifications did not exist in 2011 when the reduction plan was enacted. Continuing judicial education, effective in January of 24, the Michigan Supreme Court mandates 24 hours of continuing legal education every 2 years for each judge. This also did not exist in 2011 when the Judicial Reduction Plan was enacted. If I'm going too long, please stop me. I really appreciate your time, and I'm sorry I'm talking so fast because I just want to get all of this in. The due process impact of judicial seat elimination. First off, case backlog. Undoubtedly, a reduction to 2 judges would create delays in scheduling criminal and civil matters, most notably delaying trials and sentencing. It would create increased wait times for police, attorneys, witnesses, crime victims, defendants, and family members. Criminal trials have increased at our court by 58%. Since last year, and 6% on the civil trials. Due process for crime victims and defendants. With the sweeping changes that your Michigan legislature and the Michigan Supreme Court have enacted with criminal justice reform, the reduction plan is entirely inconsistent with those goals. Defendants and victims should not experience delays in our court system. This legislature is keenly aware of the seriousness of domestic violence. These cases require immediate attention when addressing arraignments, bond, and no contact orders. There is great concern there that there could be delays in addressing these issues immediately. Also, in my sobriety court, when a defendant violates, those violations are recommended to be treated immediately so that the defendant and the court can address what is happening with the person in treatment court as soon as possible. Negative economic impact. A slower judicial process would negatively impact businesses and those who rely on timely court decisions for property disputes, landlord-tenant cases, contract cases, and land contract forfeiture cases. Cases may also be delayed regarding SCAO guidelines for case completion. They give us guidelines to complete civil cases within 273 days. Misdemeanor cases within.
Judge, I'm sorry. I'm going to interrupt you for just a moment. If you can get it wrapped up so we can ask a couple of questions in the next minute, that would be great.
Absolutely. Chief judge duties, unlike the circuit court, the district court chief judge does not have a reduced docket. The chief judge handles budget, administrative issues, court staff working with municipalities. Lastly, it's the community outreach programs. Myself and my colleagues are very involved with the local schools. We all have field trips to the court. We are routinely going to the local middle schools and high schools to talk about substance use, making good decisions with the kids. I don't want that to be impacted. So yes, absolutely, I am here to take your questions, but on behalf of my colleagues, we are very grateful. We are seeking your assistance in passing 4833 to preserve a 3-judge bench, not create an additional judgeship. This is not creating an additional judgeship. Thank you.
Thank you. Rep. McGoal.
Thank you, Madam Chair. Thanks for coming in, Representative. You mentioned there were 7 communities. Would you happen to know the population, total community population that those judges are serving currently?
West Bloomfield and Bloomfield Township would be the biggest, followed by Birmingham, and then the city of Bloomfield Hills, Kego Harbor, Sylvan Lake, and Orchard Lake are the smaller communities. I don't want to say specifically, it's about 140,000.
Combined total?
Combined total, it could be 120. My apologies for not knowing that right now, but the district has experienced some increase in population.
Okay, thank you.
Rep. Breen.
Thank you, Madam Chair, and thank you, Judge. I actually used to practice with your husband many moons ago. Wow. Yes, I'm wondering, the SCAO report for the judicial resources does not come to the same conclusion that you have, and I'm wondering about the difference, and if you can explain why you think you arrived at the conclusion that you need some additional help on the bench. Personally, I'm inclined to listen to the boots on the ground. Sorry, SCAO, but I'm wondering if you can explain why we've got different conclusions here.
Absolutely. I received the opinion from Deputy General Counsel Trevor Van Dyke last night. I can tell you presently, we are actually under secondary review by SCAO. I confirmed that this morning with our representative, Jim McGrail, that we are under secondary review. So I was a little bit confused by the I guess the position that Mr. Van Dyke took, but let me comment on that. In this opinion, he does state that our case filings surpassed 54,000 in 2007. We were at 28,000 in 2024. We are increasing this year. Our caseload, we are expected to close at 32,800 in 2025. What must be noted here is the type of case. So when you see 54,000, candidly, more traffic tickets were being written in 2007. After COVID, statewide, and you probably know this, traffic tickets really came down and they're starting to go back up. But during COVID and post-COVID, they were coming down. So when you look at 54,000 and, you know, these high numbers, a good amount of those numbers are traffic tickets. What I'm asking you to look at are the substantive cases. When our civil caseload goes up 54% in 1 year, SCAO is actually taking note. In fact, the reason they're giving us a secondary review is because of our civil caseload. With the no-fault changes, for some reason, they are filing more cases in our court than the other courts in Oakland County. It could be for a lot of reasons. I won't speculate based on where attorneys live, where their offices are, but to have a 53% increase in 1 year, since 2021, we increased by 84%. When you look at those numbers on these third-party provider no-fault lawsuits, SCAO is really watching that. And again, that's why they're giving us a secondary review, because those cases take a lot of time. There are a lot of motions for summary disposition on really novel issues, especially with the changes in the law. So that is one of the reasons SCAO is taking another look at our court. There are other things that can't be quantified, that we service 8 different police agencies. If you take a look at most of the district courts, especially in Oakland County, that's a lot. That's a lot of different police agencies to be available for all of them. But setting even that issue aside, if you want to look strictly at our caseload, we are up this year. We are going up to, like I said, over 32,000 cases. And in large part, it is because of our civil docket, which is really exploding. On any given week, we will have dozens of motions for summary disposition, and they take a lot of time. I also want to comment on one conclusion that Mr. Van Dyke made at the end about
Judge, I'm sorry, but we really need to wrap it up. And we still have 2 more questions. I'm going to allow Rep. Breen to do a follow-up. But we really need to wrap this committee hearing up in the next 4 minutes. So
okay, I'm sorry.
This just requires a yes or no answer. Just one, you're saying that the changes to the no-fault law did not result in decreased litigation, and 2, you mentioned the rep was Jim McGrail. Is that Wayne Law Class of 01? Just want to know if we're talking about the same person.
I'm not sure, when he graduated, but he is our SCAO representative, and he confirmed this morning that we are under secondary review on the judicial needs report.
Thank you. Rep. Wozniak.
Thank you, Madam Chair. Thank you for your testimony, Judge. With regard to the total cases, and obviously you disagree with SCAO on their findings, could you clarify the docket for? And I agree with you on substantive cases that come before you now. They do take a lot more time. But what is the docket load annually for each judge, and what is your total now? Is it 32,000?
Right. We're expected to close out this year. We're preparing the budget right now at about 32,500 cases, divided by 3 judges. That would be, roughly 11,000 per judge. But I want to be really clear with you. I don't want to count the civil infractions. These are the tickets that people can come into the courthouse and pay at the counter or handle by Zoom. Those are not taking up time. I want to talk about the 5,000 and something civil cases, the criminal cases, treatment courts, search warrants, availability for the police, domestic violence cases. This is what is taking up the court's time. And when you look at some of the analysis from SCAO, they mentioned this in yesterday's summary, but what they don't mention is that because of our burgeoning civil docket, that we are under a secondary review right now.
Thank you, Judge.
Thank you. Last question, Rep. DeBoyer.
Thank you, Madam Chair. Thank you, Representative, for being here. Judge, thank you for taking the time to be here on this issue. My question is, So it's under a secondary review with scale. That secondary review could result in them changing their position, correct, on that?
Correct.
So I think first it would be prudent that we wait till that secondary review come back. And then additionally, if you do believe indeed that they come back and don't change their position, that's a broader issue, because my question to you would, how many jurisdictions have requested this type of modification? How many of those modifications have been granted? And are we going to set a precedent with the legislature just changing what Scale's perspective is based on the facts that they use? Because I would argue that Scale is the expert in the room. Whether I agree or disagree with them all the time is a different conversation. But they have a standard that they have to hold us up to. So are we ahead of that a little bit too much right now until we make that decision, I guess is the question?
I think that's a really good question. First off, Scale is saying this is a new judgeship. It is not a new judgeship. Please let me clarify that. That is maintaining the 3-judge bench. There's a huge difference there, because we are not seeking to build new courtrooms and hire additional staff. Scale makes their determination based on case analysis. They did change after 2011. Other courts were modified that were slated for either the courts combining services or having reductions. This is not entirely new, but I would say to you, if a court is seeking to change a recommendation from 2011, let them prove it. Let them prove it. And that's why I'm here to talk to you about all of these things. Your very legislature added on so many categories that never existed in 2011. And if Scale's position is they don't take extra time, well, I can tell you right now, I've got a courtroom of people waiting to expunge cases, and it takes a lot of time, and we all put great time and effort into our cases. And I would welcome any of you to come here. I have invited Scale and their analysts to come here and watch what we do. Please don't look at this as a numbers game, because when you start to look strictly at numbers, you have to look at what type of cases we are all talking about and whether we're on the same page.
Thank you, Judge. Thank you, Rep. Steele, on Rep. DeBoyer, to answer your question too on a committee level. This is obviously, we did Roth today. It's a topic of conversation. As bills got dropped, information has come to light, but it's being reviewed. So we're not moving these right now. We're just doing testimony. But in regards to that, House Bill 4833 does not wish to speak, opposes the bill, and has submitted written testimony already is Trevor Van Dyke of Scale.
Thank you.
With that, seeing no further business before the committee is adjourned.